Alright, Chapter 31, Inter-Parties Review. Inter-Parties Review, Applicability Provision, Inter-Parties Review Petitions. Preliminary Response Petition, Institution, Inter-Parties Review, Relation to Other Proceeding Actions, Conduct Inter-Parties Review, Settlement Decision of the Board Appeal, Title 35 U.S. State Code 311, note with the Inter-Parties Review Applicability Provision, the Post-Grant Review Provisions, Lehigh-Smith American Inventors Act, apply only proceeding commenced on after September 16, 2012, except with extension of the jurisdiction of the United States Courts of Appeal for the Federal Circuit and appeal for the decision patent travel appeal board re-examination under amendment made with the subsection C2 American Invention Act shall be deemed to take effect for September 16, 2011, shall be examined with the decision of Board of Patent Appeal for the interference with respect to the re-examination is entered before on after September 16, 2011. And provision with the Title 35 U.S. Standard Code 6 and 141 in effect with September 15, 2012 shall continue to apply for the inter-party re-examination request under Title 35 U.S. Standard Code 311 for September 16, 2012. Patent Trial Appeal Board may be deemed to be with the Board of Patent Appeals and interference with the purpose of appeal for the inter-party examination requested under Section 35 U.S. Standard Code 311 for September 16, 2012, and for the Director's rights under the fourth sentence of the Title 35 U.S. Standard Code 143, intervening any appeal for the decision extensive of the impact of the Patent Trial Appeal Board shall be deemed to extend with the inter-party re-examination that are requested under Title 35 U.S. Standard Code 311 before September 16, 2012. Title 35 U.S. Standard Code 311, the Inter-Parties Review. In general, some provision of the chapter for the person who does not own the patent may file with the office of the petitioner institute with the Inter-Parties Review of the patent, and the Director shall establish regulation fees to be paid person requesting valid review. Such amount with the Director determine the reasonable consider the aggregated cost of the review. Scope of the petitioner Inter-Parties Review may right to cancel. Request to cancel unpatentable one or more claims of patent only when the ground could be raised under Section 102 or 103 only on the basis private with the consisting patents and printed publications. Filing deadline, petitioner inter-parties review shall be limited to file without later, either for the date of the 9 months after the grant of the patent, 2 for the post-grant review for the institute under the Chapter 32 for the date of the termination such grant review. Title 35 U.S. Standard Code 312 petitions. Requirements of petition filed within Section 311 may be considered only if the petition accompanied by the payment of the fee for the established by the Director under Section 311. 2. Petition identifies all real parties and interests. 3. The person identified with the writing with the particular with each claim challenge of the grounds on which the challenge of each claim is based. Evidence for the support of the grounds of challenge of any type. Each claim. And 4. A. The copies of the patent printed publication petition relies on support with the petition. B. The affidavit of declaration support with the evidence option. Petitioner relies on experts' opinion of the petition, provides for the other information that the Director may require for the regulation. Petitioner provides copies of any of the document required on paragraph 2, 3, and 4. Patent owner applicable to designated representative of the patent owner. B. Public availability as soon as practicable after receipt of the petition under Section 311. The Director shall make the petition available to the public. Title 35 U.S. Standard Code 313 Preliminary Response Petition. Inter-party for the review petition filed under Section 311. The patent owner shall have the right to file preliminary response with the petition with a time period set by the Director sets. For the reason with no inter-party review shall be instituted based on failure of the petition to meet any of the requirements of the chapter. Title 35 U.S. Standard Code 314 Institution of the Inter-Parties Review Threshold. The Director may not authorize the inter-party of the review to be instituted. The Director determines the information presented with the petition filed under Section 311A, but the response filed under Section 313 shows that if there is reasonable likelihood the petition would prevail with respect to at least one claims challenge of the petition. Timing with the Director shall determine whether the institute of the inter-parties review under the chapter of the pursuit of the petition filed under Section 311 3 months later. After receipt of the primary response with the petition under Section 313, no preliminary response filed of the last day, but such response might be filled. D. Notice of the Director shall notify the petitioner patent owner writing to the Director in for determination under the subsection A shall to make such notice available to the public as soon as practical. Such notice include date which review shall commence. No appeal determination by the Director whether the institute of the inter-parties review under section shall be finally non-appealable. Title 35 U.S. Standard Code 315 Relation with the other proceeding action. Infringer civil action, inter-party of the review, barred of civil action, inter-party of the review, but may not be instituted if before the day of the petition such of the review is filed with the petitioner real party interest filed with civil action challenge validity of the claim of the patent, stay of civil action. If the petitioner real party interest files the civil action challenging validity of the claim of the patent on or after the date at which the petitioner filed the patent for inter-party review, patent the civil action should be automatically stayed until either the patent owner moves to the court to lift its stay. Patent owner filed the civil action counterclaim alleging the petitioner real party interest has infringed the patent. C. The petitioner real party interest moved the court to dismiss the civil action treatment of the counterclaim, and the counterclaim challenging validity of the claim, and the claim does not constitute with the civil action challenging validity of the claim. Patent purpose section. Patent owner action. Inter-parties review may not be instituted with the petition requesting proceeding filed more than 1 year after the date of the petition. Real party interest private petitioner served of the complaint alleging infringement over the patent of the time of the limitation set forth the proceeding set forth shall not apply with the question joiner under section C. Joiner, if the director instituted the inter-party review, the director at his discretion may join a part of the inter-parties review. Any person promptly files of the petition under section 311, the director receiving preliminary response under section 313, expiration of the time following such to respond to the termination warrants institution inter-parties review under section 314. Multiple proceedings notwithstanding section 135A or 251, 252, Chapter 30, during dependency inter-parties review with another proceeding and involved with the patents before the office for the director determines the manner of the inter-parties review of the other proceeding, the matter may proceed, including providing sale, transfer, consolidation, termination, any such matter proceeding. Estoppel proceeding before the claim and the petition of the inter-parties review of the claim and the patent under the chapter resolve of the final written decision under section 318A or a real party interest or provide the petitioner may not require the maintaining the proceeding with the office for the respect of the claim and on the ground with the petitioner raised on the reasonable could have raised during the inter-party review. Civil actions over the proceeding, the petitioner and the inter-parties review of the claim patent under the chapter result of the final written decision, section 318A, the real party interest of the private petitioner may not assert that either the civil action arising in whole or in part, or in section 1338, title 28, or in proceeding before International Trade Commission under section 337, the title Tariff Act 1930 claim and invalid any ground petitioner raised and reasonably could have raised during the inter-parties review. Title 35 U.S. Code 316 Conduct Again Party Review Regulation. Director shall prescribe that the regulation providing file any of the preceding chapter made available to the public except with the petition. Document filed with the intent with the be sealed shall be accompanied with a motion to seal and treated with the sealed pending of the outcome of the ruling on the motion. 2. Set forth standing for the showing of the sufficient grounds to institute the review under section 314A. Establish proceed with the submission of the supplemental information after petition filed. Establishing governing inter-parties reviewed under the chapter relation to the reviews to the other proceeding under the title of the set forth standing for the procedure for the discovery of the relevant evidence, including such discovery should be limited to aid with the disposition witness submitting affidavits or declarations will be otherwise necessary the interest in justice. 6. Prescribing sanction abuse of the discovery abuse of the process of the improper of the proceeding such wrath and such an unnecessary the delay with the unnecessary increase of the cost of the proceeding. 7. The providing with a protective order governing with the exchange with the submission of the confidential information providing with the filing of patent owner with the responsible petitioner in section 313. Inter-parties review instantly requirement of the patent owner the file the top of the respond with the affidavit, the declaration, additional factual evidence, expert opinions on which patent owners rely on support response. 9. Setting forth standing procedures aligned with the patent owner to remove the amendment of the patent in subsection, cancel the challenge claim, and the purpose of the response, reasonable number of substitute claim, ensure for the information submitted to the patent owner, support for the amendment, and enter for the other subsection to be made available to the public part of the prosecution history of the patent. Providing either party with the right of oral hearing as part of the proceeding, require that the final determination inter-parties review the issue no later than 1 year after the date of the director notice of the institution review under this chapter, except that the director may be the good cause shown in the extent of the 1 year period. No more than 6 months may be the adjust for the time here is paragraph of the case of joiner under section 315C, the 12 the inset time period requesting joiner under section 315C, and 13. Providing petitioner with at least one opportunity to file a written comment at the time period established by the Director. Consideration prescribing regulations under this section. The Director shall consider the effect of the regulation economy with the integrity of the patent system and efficiency, administrate the office ability of the office of the timely complete proceedings instituted under this chapter. Patent Trial Appeal Board, Patent Trial Appeal Board in accordance with Section 6. Conduct each of the parties reviewed interested in the chapter amendment of this patent general during inter-parties review instituted with the chapter. Patent owner may file one motion to amend patent one or more following ways: cancel and change patent claim. For each change, challenge Catman purpose of the reasonable number of the substitute claims. Additional motions to amend the permitted done by the joint request of the petition for the patent owner with the material advance for the established proceeding under Section 317, or as permitted by the regulation prescribed by the Director's scope of this claim. With this amendment under the subsection that enlarge the scope of the claims of the patent, introduce the new matter, evidentiary standards, the inter-party for the review, the institute of the chapter petitioner shall have the burden of proving with the proposition on ability by the preponderance of the evidence. Alright, Title 35 U.S. Code 317 General. Settlement General. Inter-parties reviewed instituted under the chapter shall be determinative of the respect of the position upon joint request of the position patent owner unless for the office to decide the merits of proceeding before the request for determination is filed with the inter-party of the review with determinative respect to a petition under the section estoppel under Section 315E, such extent attached of the petition, real party interest of the private for the petitioner on the basis of the petitioner institution of the inter-parties review. No petitioner remains inter-parties review. Office may be terminate review the process, final writing a decision under Section 318A. Agreements in writing. Any agreement to understand between the patent owner and the petitioner, including collateral agreements, referred to such agreements under understandings made in connection with the contemplation, termination, or of the inter-parties review under section shall be written with a true copy of such agreement. The understanding shall be filed with the office before termination. Inter-parties review between the parties. The at request of the party proceeding agreement to understand with the business confidential information shall be kept secret, separate from the file involved with the patent, shall be made available only with the federal government agencies' written requests or to any person showing them the good cause. Title 35 U.S. Code 318 Decision of the Board. Final written decision. If the inter-parties review the institute with the dismissed under this chapter of the Patent Trial Appeal Board shall issue the final written decision with respect to the patentability of any patent claim challenged by the petitioner. Any new claim under Section 316G, the certificate of the Patent Trial Appeal Board issue with a written decision under Section 8 of the time for appeal with express that any appeal terminated with the Director shall issue the published certificate canceling any claim of the patent finally determined to be unpatentable, confirming any of the claim patent determined to be patentable, incorporating patent operating certificate, any new and amended claim determined by the patent. Intervening rights, the purpose of amendment of the new claim determined the patentability incorporated into the patent following the inter-parties review of the chapter shall have the same effect specified with the 252 reissue of the patent right of any person who may with the purchase within the United States imported with the United States. Anything patent such proposed amended new claim or who had made substantial preparation therefor before issuing the certificate under Section B. Data of length of the review office shall make available the public data describing the length of the time between the institution and issuance of the final written decision under Section 8 of each of the inter-parties review. Title 35 U.S. Code 319 Appeal of the party dissatisfied with the written decision of the Patent Trial Appeal Board under Section 318A, then they appeal with the decision pursuant to Section 141, 140, and 144. Any part of inter-parties review shall have the right to a party then appeal. Chapter 31 Pre-American Inventors Act Optional Inter-Parties Re-Examination Procedures.